4 pieces of evidence revealed at our September 9th press conference have thoroughly unveiled Tsai Ing-wen's academic fraud. This ruse has played out over the past 37 years. An employment history form from 1984 that Tsai filled out with a previously unheard-of dissertation title proves that she never completed her so-called thesis. Archived files from NCCU prove that Tsai circumvented protocol and became an associate professor without proper examination, approved documentation, or a thesis. Three different versions of a letter written by University of London administrator P.C. Kennedy proves that Tsai's side has been tampering with and forging documents this entire time. Finally, IALS's sequential thesis numbering system proves that the school never received a copy of Tsai's thesis, eliminating the possibility that libraries lost it. As if the damning evidence weren't enough, Tsai Ing-wen's lawyer Lien Yuanlong produced new documents that indicate Tsai's viva took place on October 17, 1983, and not on October 16, 1983 like we've been led to believe over the past 2 years. Furthermore, Lien says that according to Tsai's memory, she had a third examiner at her viva, Dr. Richard Dale. Tsai's team is doing whatever it can to keep up its crumbling facade. Tsai Ing-wen has long lost the trust and confidence of the people. At this point, the only thing Tsai can contribute to Taiwan anymore is the judicial reform that will come once this academic scandal is brought to justice.
您是处于比较劣势的，您的下一步可以透露给我们吗？还是说你手上有什么关于蔡总统论文的比较新的一些证据或发展？可不可以预告一下，告诉我们观众朋友？
Despite revealing such damaging and hard-hitting evidence in the September 9th press conference, Taiwan's mainstream media continues to turn a blind eye to this scandal. It acts as if ThesisGate isn't there and barely gives the scandal the attention it deserves. Not one reporter has demanded answers from the presidential office, sparing Tsai Ing-wen from the clamps of public pressure. These actions are tantamount to covering for Tsai Ing-wen, and it is a failure of the fourth power. Tsai's team also tests the limit of their own shame. It's not enough that they alter history, they flat out change established facts like Tsai's Viva date. They act with such impunity because they know that Taiwan's judicial, legislative, and administrative mechanisms won't stand in Tsai Ing-wen's way. It's obvious that domestic influences will not be enough to bring Tsai to justice. Since Taiwan's internal ThesisGate movement faces such suppression, Dr. Dennis Pang appeals to people abroad. He has embarked on a lecture tour to try and rally support for the global movement. Dr. Pang first spoke at the Taiwan Benevolent Association of America's annual convention on September 17th to share his findings.
潘怀宗议员就是那个把 蔡英文在东吴大学1983年8月1号就去任职的那个通讯录给了我的人，结果过了不到2个月，他被收押，而且呢，理由就是诈领助理费。总之，蔡英文用高压的手段跟司法，一个一个在对付反对他的人。
Less than 2 weeks later, on October 2nd, Dr. Pang had made his way from the eastern United States to the West Coast. In San Francisco, he reported on how extensive Tsai's fraud schemes were.
一般人会有一个直觉认为，英国伦敦大学怎么可能作弊？但是这个逻辑，如果我们更上纲的话，干脆说总统怎么可能说谎？所以这个不是答案。对，这绝不是答案。 这就等同于说，总统怎么可能说谎一样？我们今天就是在揭露总统说谎，我们就是在揭露英国伦敦政经学院在这个事件当中一定程度的包庇，隐匿了蔡英文的诈骗犯行。
On October 16th, Dr. Pang traveled to Los Angeles and spoke to the Chinese American Professional Society about ThesisGate's implication for judicial reform.
如果我说的东西是事实，何来之罪呢？就算我心生怨怼吧，就算我增加收入吧，如果我讲的东西是事实，我哪来的罪呢？所以论文门，我跟我的2位律师说，我到了法庭，我要放弃言论自由的抗辩，我绝不主张言论自由，请不要告诉我我是因为言论自由而获无罪。我要告诉你的是，因为我讲的东西都是事实，请法官不要用，我绝不接受你用言论自由替我开罪。这是我跟我的2个律师讲好的，我在论文门当中的所有辩护，我的原则。好。
In less than a month, Dr. Pang traveled across the US to give 3 lectures. Each one delved into Tsai's scandal and how she has spent the judiciary to her will. Dr. Pang's lectures won ThesisGate much-needed support. Dr. Xu Yongtai attended the Los Angeles lecture to endorse Dr. Pang's efforts. Mayor of Walnut, Eric Ching, and Mayor of Cerritos, Grace Hu, attended the lecture as well. This series of lectures across the United States helped keep the ThesisGate conversation in America alive. Unlike in Taiwan, much of the overseas community rallied around Professor Pang. The overseas community independently formed a truth-seeking coalition to help Dr. Pang. They invest time and money in his cause. They were the ones that carried out a newspaper ad-buying campaign that called for Tsai Ing-wen to step down. This campaign started in Chicago on October 10th before moving on to Taiwan. Newspapers in Australia and other American cities followed suit with their own ads. After that, the movement fizzled out momentarily before finding a second wind and continuing in Canada. On October 18th, Vancouver and Toronto's largest Chinese-language newspaper published an ad calling for Tsai Ing-wen to step down. Furthermore, they called for live streaming in the courts. In 2019, ThesisGate investigators sought to hire an attorney in the UK to carry out litigation against the University of London. At the time, law firms estimated that the case would require £1 million British in legal fees, and that was just a preliminary quote. Professor He Defun thought it unwise to throw so many resources at a single endeavor. Instead, the money was diverted to fund other ventures like the Freedom of Information Act inquiries and litigation in Taiwan. At the time, the UK lawyers agreed that pursuing Freedom of Information Act inquiries were the best course of action. That way, investigators could slowly build their case. After all, they were dealing with one of the best legal education institutions in Europe. Tsai and her people would never accept responsibility so easily. In the 2 years since Dr. Huan Lin published his independent report, Tsai's team has constantly tampered with and altered evidence. However, their forgery is catching up with them. There is now enough to merit a criminal trial against the University of London. The most crucial evidence in this criminal case will be the contradictory statements the school has made to conceal Tsai's misconduct. Before ThesisGate caught widespread attention, the London School of Economics' library said, "Unfortunately, Senate House apparently never received a copy and the IALS are unable to find their copy. But afterward, it said, is missing." But Dr. Lin received a response from the University of London saying, "Senate House Library never received the original copies of this thesis from external examiners." This statement proved that in 2011, a copy of a thesis was submitted but ultimately rejected. To keep covering for Tsai, the University of London tried to write off the lack of a thesis as a mistake. It wrote, The original copy held by the university library was lost or misshelved sometime between mid-1980s and 2010s, but after a little more digging, Dr. Huan Lin found out about IALS's sequential numbering system, thus rendering the University of London's statement false. More contradictions can be found in statements about Tsai's diploma. In 2015, Tsai revealed the diploma, which was a reissue from LSE. Many found problems with that document's formatting. Dr. Lin reached out to the school's diploma production office, which said that reissues will of course still be identical to the original document, same wording, same signatures, etc. However, the LSE's Public Relations Department later on said that the Diploma Production Office made a mistake. This was an error. However, none of these explanations can account for the fact that the reissued diploma had dozens of glaring issues. After 2 years of examination, investigators found out that diplomas from the school can only be reissued once. Not only that, but all reissues will have serial numbers on their backs. Tsai's reissued diploma did not have a serial number. Pointing out the missing serial number had its advantages. The copy of Tsai's 2015 diploma cited in Huang Wei's indictment papers had a serial number, meaning someone had tampered with the diploma. Of course, there's also the matter of LSE Information and Records Manager Rachel McGuire's claim that Tsai's Viva took place on October 16, 1983. Legal representative Kevin Haynes' 298 pages of files indicating Michael John Elliott and Leonard H. Lee were Tsai Ing-wen's examiners, and Luis Nadal's claim that LSE had no records on Tsai Ing-wen's PhD. After 2 years of collecting these testimonies, one thing has become clear. It's time to take action against the University of London. We are well prepared to go toe-to-toe with one of the world's top education institutions. In the defamation case against Xavier Chang, Judge Zhou Yuxuan's request to obtain testimony from the University of London was blocked by the Foreign Ministry. Then, later on, she was switched out for another judge. Ever since that moment, it became clear that we cannot trust Taiwan's judicial system. That's why we requested live streaming trials, for transparency. On October 20th, in Tsai Ing-wen's defamation case against Dr. Dennis Pang, Judge Yao Nian-ci and prosecutor Liu Cheng-wu held a pre-trial hearing. Before this hearing, Dr. Dennis Pang made 3 requests to the court, going so far as to submit 14 written requests asking for 1. Document access, 2. Adding violation of election laws to Dr. Pang's charges, and 3. Live streaming court procedures. The only one of those requests to receive any attention was the stream request. The other 2 were tossed to the wayside and completely ignored. Any hope Dr. Pang harbored for having his requests at least discussed under Judge Yao and Prosecutor Liu disappeared. The courts, once again, have become a witch hunt. At the hearing, Judge Yao asked why Dr. Pang was not in attendance and asked the prosecutor to present his opinion. Prosecutor Liu held nothing back, giving some scathing thoughts. He said that Dr. Pang had plenty of notice and time to make it to the hearing. Liu said that Pang's negligence disrupted court procedures. He said that Dr. Pang traveled to America almost as if he were fleeing. Liu asked the courts to put out a warrant for Pang's arrest. Judge Yao then asked the defense's representatives to offer an explanation. Just as attorney Jim Chang was about to read a statement from Dr. Pang, Judge Yao cut him off. The judge told Chang that she didn't want to hear any irrelevant statements and only wanted to know why Dr. Pang wasn't present. Chang said that the reason was in the statement, and only then did the judge let him proceed. However, as Chang began talking about Tsai's fake degree, the judge interrupted him again, demanding a reason for Dr. Pang's absence. The judge unreasonably cut Chang off several times while he was reading Dr. Pang's statement. However, if she wanted to know why Dr. Pang didn't show up, then his statement in its entirety should have been prioritized. Judge Yao's moderation of the hearing was problematic. Attorney Li Zhenghua spoke up to correct the prosecutor's understanding of pretrial procedures, but was once again cut off by the judge who only wanted an explanation for why Dr. Pang didn't show up. Li then said his concerns were relevant because in criminal cases, even if a defendant didn't show, regardless of reason, the pretrial hearing could go on as planned. The judge interrupted Li and again insisted that she only wanted a reason for why Dr. Pang didn't show. Only then could she decide whether a warrant for his arrest was necessary. Judge Yao took full control of the preliminary hearing. She constantly interrupted the defense's statements despite Li having legal basis for all of his arguments. It's clear that the judge had already made up her mind even before consulting the defense. After that, everything ran like a well-scripted show. Judge Yao asked Prosecutor Liu to respond to the defense's claims that the pretrial could move forward without the defendant. Liu said that the case at hand was special. He said that it revolved around discerning whether or not Dr. Pang acted out of malice or revenge, and that was something that couldn't be determined through the defense's attorneys. Another important point in the case was to decide whether or not Dr. Pang's statements against Tsai were to raise his ratings and viewership, and that was something only Dr. Pang could speak to. Liu said that Pang's charges are of a subjective nature, and that's why his presence was required for the hearing. Liu also added that Pang's claims that he was being followed and watched were bogus and unfounded, since he could escape to the US to evade the trial. After Liu's response, Jim Chang said that the court was welcome to issue a warrant for Dr. Pang's arrest. Chang said that Sun Yat-sen was also tagged with dozens of warrants in his time. He said he found Liu's claims that he wasn't fit to speak on Dr. Pang's behalf absurd. Chang said the prosecutor's claim that Dr. Pang acted out of hostility and for monetary gain was absolutely unproven. He asked why the prosecutor was so sure that was the defense's motive. Chang's response to Liu drew laughter from spectators. Judge Yao did not seem happy and told the bailiff to dole out warnings to spectators who so much as showed a smile. Lawyer Li Zhenghua then asked the judge if she had made up her mind. Judge Yao said she hadn't. Judge Yao's next move seemed to target the defense's lawyers. She said that the defense's written requests did not have the defendant's signature, which made it impossible to verify if the defendant actually made such requests. She said that she couldn't ask for confirmation since the defendant wasn't present. This confused and shocked the defense attorneys. Judge Yao had a court clerk project the documents on a screen and read them out loud one by one and check to see if they were signed. She then turned to the defense and said, "I thought your case was built around the inconsistent format of Tsai's thesis. How did you mess up formatting for your own documents?" She then told the defense to correct the documents. Lawyer Chang couldn't contain his frustration and told the judge that the defense would correct the forms. However, he said that in his 30 years of practicing law, not one judge had asked him to do such things. Li Zhenghua also said that he never met a judge who insisted on seeing defendants' signatures on such documents. Judge Yao cut the two attorneys off and said that she was clear and adamant in her decision-making. Whether or not the defense wanted to make up the materials was up to them, but that was how she was going to do things. No lawyer has ever encountered such a situation. Judge Yao was purposefully giving the defense a hard time. It was as if she was stalling so she could avoid responding to the defense's 3 requests. Judge Yao knew that the 3 requests would be detrimental to Tsai, so she took a heavy hand and gave the defense a hard time, saying that the defendant's absence and their missing signatures violated court rules. Yao's obstruction was nothing more than a mere pre-planned charade. Her intention was to find a way to neutralize the 3 requests. If the defendant's absence really presented that much of a problem, then why did the judge even ask for the attorneys to offer an explanation? Isn't that a little contradictory? The judge then turned to the plaintiff's representative, Tsai's lawyer, and asked for their opinion on how to move forward. Jim Chang cut the judge off there. Li Zhenghua followed up by saying that the judge couldn't ask the plaintiff representative for their opinion. Chang said that according to an amended law, the plaintiff shouldn't be notified of the pretrial hearing's time and place. That meant they shouldn't have even been there, much less offering opinions. Li thought it was absurd that a plaintiff representative was allowed to supervise a prosecutor. However, the judge insisted on having the plaintiff express their opinion. Jim Chang immediately objected, but the judge asked on what grounds he made the objection. Judge Yao said it was her time to speak and that Chang couldn't object. Li Zhenghua started looking for relevant laws, with Chang stating that the plaintiff representative shouldn't even have been present. He said the judge should have ejected them from the courtroom. Chang asked why he couldn't object if there was misconduct going on in the court. Li also protested the judge's actions. He said that she was overly nitpicky with the defense, but she extended many liberties to the plaintiff. Now she was limiting the defense's right to object. What was going on? That was when Judge Yao began reciting the Court Organization Act. She said that if a lawyer is found speaking out of line, then the presiding judge has the right to hold them in contempt, and can even outright prohibit them from speaking. Judge Yao held Li and Chang in contempt for speaking out of turn, disrespecting the court, and disrupting order. The bailiff issued warnings to the two. Judge Yao then recited a law that said plaintiff representatives were allowed to offer opinions in trials. The two lawyers then said that they were at a preliminary hearing and not an actual trial. Ever relentless, the judge insisted that according to the law, trials include all trial procedures, including formal trials, pretrial hearings, and debates. At this point, Li found a law countering the judge's explanation. The law said that only in cases dealing with serious crimes like murder, arson, rape, robbery, and human trafficking can a plaintiff and their representative attend pretrial hearings. In this particular case, a plaintiff representative's presence was not merited. Li added that the current case under consideration is a high-profile case. The judge's unlawful behavior and suppression of the defense will not stand. The defense will be heard whether inside or outside of the courtroom. Judge Yao said that the defense's objection had no grounds. She said that the law Li cited was relevant in a different context and therefore didn't apply. The defense had made a mistake. Then, out of nowhere, Judge Yao dismissed the hearing. This was unexpected and caused an uproar. It seemed that Judge Yao realized that she had broken the law by asking the plaintiff representative to voice their opinion. Otherwise, why didn't she continue the hearing after dismissing Li's objection? Why didn't she hear Tsai's lawyer's opinion? Judge Yao had to leave quickly after Lee reminded her that they were dealing with a high-profile case. The courts know that ThesisGate cases draw widespread attention, meaning they couldn't deal with it quietly through simple court procedure. Tsai Ing-wen's people want nothing more than to handle this case by rigging the system. In the preliminary hearing, Judge Yao only asked 2 irrelevant questions that had nothing to do with proper procedure. One was why the defendant was absent, and the other was why defense documents weren't signed. Those 2 questions should not have been the focus of the pretrial. Preliminary hearings should have been about going over evidence, preparing summons for intended witnesses, and deciding how to carry out the trial. More importantly, the pretrial should have addressed the question of streaming. However, Judge Yao's sudden retreat from the stand during the pretrial hearing and her sudden warnings to the lawyers were indications that things were not going according to Tsai's plan. Prosecutors are seeking a warrant to arrest a scholar because that scholar questioned the legitimacy of a president's degree. ThesisGate is no longer a matter of simple fraud. It has also exposed the inadequacies of Taiwan's judicial system and human rights standards. We don't know what kind of shady dealings are going on behind the scenes. ThesisGate is a war of attrition, and that's why it needs all the support our viewers can muster. Do not stop lending the movement your voice. Participate and petition. We implore you to press on and persist.